Good afternoon, everybody. The webinar will start shortly. We're just waiting for some more participants to head over and we'll make a start soon. Good afternoon, everybody. My name is Annette. I work within the marketing team at HR Assured. I hope everybody is well today. We're going to make a start on the webinar, Termination Without Tears. So I'll just get to the next slide here, if that's okay. If you're not familiar with HR Assured, our HR and WHS solutions business is part of FCB Group. We help businesses navigate around Australia and New Zealand's complex employment laws by providing a range of services and products to ensure businesses are compliant. When you partner with HR Assured, you'll have access to our award-winning services, including our 24/7 telephone advisory service, comprehensive HR and WHS audits, HR and WHS software, insurance and representation, and a library of legal resources. So today's webinar will be presented by our Senior Workplace Relations Consultant, Emily Fisher. Emily handles complex workplace issues and she has a special interest in providing clients with comprehensive advice and solutions to ensure they can promote a functioning and compliant workplace. Today, Emily will be focusing on termination and why businesses need to ensure they follow a fair and compliant process. Now, before we begin the webinar, I just wanted to remind the audience that if you do have any questions along the way, feel free to pop them in the Q&A chat feature just below here, and we will address them at the end of the presentation. Okay, so let's make a start. Hi, Emily, how's your day going?
Pretty good. Thanks, Annette, and thanks.
Good.
Thanks everyone for joining today. Look, I'm really excited for this webinar. There really is a lot to get through because termination and termination processes is, a really large topic with lots of factors to consider. So the main kind of focal points today will be on the risks surrounding termination processes, procedural fairness, and the actual termination process itself. And I did want to say again that we will have time for a Q&A at the end. So please do put your questions in. The Q&A part of Zoom is the preference because it means we have all of them there, but we will try and get to everyone's questions at the end. So look, what today's presentation really does revolve around are some of those key things that employers and managers need to keep in mind where they are undertaking a termination process, or also the processes that generally lead up to termination itself. And so we're going to talk about the risks that kind of arise where these processes and procedural fairness requirements aren't met. So we've called this webinar Termination Without Tears. And look, I really think that this is relevant from a tears perspective from both of the employee and the employer. So where process and procedural fairness requirements are met, generally I think a termination process will be an okay experience for both parties. And I say okay because I think termination processes generally can be really difficult, both for the person being terminated and for the person doing the terminating. So I just wanted to briefly start by kind of identifying the circumstances where terminations will generally arise. And I think where they normally arise after, elements of consistent poor performance, conduct or serious misconduct issues, a breach of policy and procedure, a breakdown in work relationships, but then also redundancy as well. So there are other exceptional circumstances where termination will arise, but generally in my view, I think that termination will always be an outcome of one of these categories. So when undertaking a termination process or an employment practice that may potentially lead to termination, it is incredibly important that you are able to identify what the reason for termination is and whether it is a lawful reason in accordance with the Fair Work Act. So the reason for this is that there are different procedural fairness requirements that need to be met in order to have a reduced risk process of termination. So look, there are a number of reasons I think why employers shouldn't just terminate on the spot without a formal process. But I think the first key reason is that it really does mitigate claims within the Fair Work Commission. There are two types of claims that I am going to focus on in particular in this webinar, and that is because they are typically the most common claims that come through, and the two claims that have really clear and quite easy to follow procedural fairness requirements that will result in a mitigation of this type of claim being made. Another thing that you need to consider is potential reputational damage. Now, I think this one isn't always considered. So where an employee makes a claim for general protections or for unfair dismissal and it's dealt with at conciliation, that's fine because the conciliation process is kept confidential. But if for whatever reason it's not settled at conciliation and it moves forward to a hearing, this information is generally public. And I think often there are kind of articles that come out of businesses that have done the wrong thing, not followed a process around a dismissal. And that kind of info and that problem is then in the public domain. And I think this is particularly important where you've got current staff that are able to find this out, or where you've got new staff that are potentially looking to come on with you. And when they Google your business, there's an article that might pop up or something that pops up that talks about a non-compliant employment process. So that's a really important one to consider. Look, I think the next one is just general fairness. So termination processes can be really difficult for both parties. So generally, it is really important that a fair process is undertaken because it can make it less stressful for all parties involved. And lastly, undertaking a procedurally fair process may at the beginning seem like it is a bit of a lengthy process that requires the input of a lot of internal resources. But I really do believe when a process is best practice and compliant, it does become significantly easier in the long run. So where you haven't been following procedural fairness initially in the beginning, it can result in a process becoming more time consuming because there can often be disputes that are raised in relation to the termination process or any disciplinary or performance management process that is being relied upon in termination. And that dispute in relation to the process in and of itself creates most of the time an entirely new process that needs to be dealt with before a termination can take effect, because an employee has raised a dispute or a grievance in relation to the process itself, which they can do. And I guess we'll talk a little bit about this when we get to the general protections termination risks. Look, now, normally when I do these types of webinars, I do leave talking about the risks to the end, but I think it's really fitting today to talk about these first. I think it will allow kind of everyone on this webinar to think about what the risks are and keep those in the back of your mind when we start looking at process towards the end, because you'll clearly be able to link back the procedural fairness elements that we will talk about to some of the elements of risk in general protections and an unfair dismissal. So the first risk that I wanted to talk about, or first claim, is a general protections claim. So these types of claims arise where an employee or prospective employee has a workplace right, they have or have not exercised a workplace right, or they are proposing to exercise a workplace right, and an employer takes adverse action against the employee for the reason of that workplace right, whether they've exercised it, proposed to, or they haven't. So adverse action can typically, it's not simply just termination. So this type of risk is not only applicable to the termination process itself, but also all the other potential disciplinary or performance processes that you'll later rely on. And so adverse action typically comes in the form of dismissal, injuring an employee's employment. So that might be taking away something they might otherwise have had access to. Point C there about altering their position to the employee's prejudice. Sometimes I get questions around, that an employee's been underperforming, or they've raised some complaints in relation to their role. Can we give them a demotion or change their role in any way? And absolutely not. It is a form of adverse action, so we do need to be mindful there. And another form of adverse action that we sometimes see is discrimination. So that's what the general protections kind of rules generally revolve around. So an employee has exercised a workplace right, and then there's been a subsequent detriment because the employee has exercised that workplace right. So we get the question a lot about what is a workplace right. Generally, the ones that arise and that we see the most is where an employee is entitled to a benefit under a workplace law or an instrument. So an example of this would be sick leave is a workplace right. So where an employee takes a period of sick leave and we're wanting to terminate subsequently after the employee's taken sick leave, there is close proximity to an employee having exercised a workplace right. So sometimes when I'm talking to clients around that, we say, even if there are other reasons for termination, where it is close to the employee having exercised a workplace right, it's just one of those things to consider. Proximity isn't the only thing that the Fair Work Commission will take into consideration, but it is a factor to think about in terms of moving forward with a termination. And I think there are other ones that we get as well, but I think the main one that we also get in terms of where employees are exercising their workplace right is really around making a complaint or inquiry in relation to their employment. So that can take the form of an employee might make a bullying claim or raise a dispute with another employee or in relation to their manager. They might ask for a pay rise. They might start questioning terms and conditions of their employment contract. They may even just question a lawful and reasonable direction or something like that that's been given by their manager. So any complaint or inquiry should be dealt with prior to any termination claim being made. And look, that's a bit of a general statement, and sometimes that doesn't necessarily apply. But I really do think where an employee's exercised a workplace right, and we're trying to think about termination, even where it's for a completely unrelated reason, it can give rise to a potential general protections risk. So it's a really, really important thing to consider if we're looking at termination. So who does general protections apply to? Look, unlike unfair dismissal, it is one of those claims where it pretty much applies to everyone. So it's all employees, full-time, part-time and casual. Even if they've worked 1 second or 1 minute, it will still apply to them. So it does apply to people within the probationary period and the minimum employment period. It doesn't have that exclusion like unfair dismissal does. It also applies to apprentices and trainees, fixed-term employees and independent contractors in some circumstances. And on that part as well, general protections can also apply pre-employment. So in the recruitment process, there are general protections risks there where an employee starts asking questions about the contract or about their pay or anything like that. If we're making the decision not to hire an individual based on that factor, it can also be general protections. So that's not necessarily related to the termination process, but it is something to keep in mind in the recruitment stages. With general protections, there's what we call a reverse onus of proof. So it means that if an employee makes a claim and says, I raised a complaint around my pay and I was terminated as a result of it, it is not a matter for the employee to prove that that's the case. The employer must demonstrate that it was not for that reason, it was for another. And this reverse onus of proof part is where it becomes really important around process and procedural fairness. Because if an employee raises a general protections claim, even if you know it was for another reason and not the workplace right that they are saying that they have or have not exercised, you will have to demonstrate that it was for another reason. Now, if you haven't done a formal performance management process that's documented, you haven't undertaken a procedurally fair disciplinary process, we don't have warnings, any of those things, the reverse onus of proof then becomes incredibly difficult because you don't have a documented process in writing about why termination did occur for a reason that wasn't the workplace right. And that is typically where you will become undone. So when clients are coming to me and asking me about what process they have to undertake or how airtight is their process, one of those things that we really do look to is whether there is a general protections risk. Because if there is a general protections risk when it's completely unrelated to the actual process, but the process isn't documented, the risk is heightened there. So it's certainly something that we think about, and it highlights the importance of these procedural fairness elements that I'm going to go through shortly. So the next kind of risk we've got is unfair dismissal. So look, I think unfair dismissal can be a little bit more simple than general protections. So unfair dismissal is where a person's been dismissed. The dismissal is considered harsh, unjust, or unreasonable. It's not consistent with the Small Business Fair Dismissal Code, or the dismissal was not a genuine redundancy. So an person has access to unfair dismissal where they are covered by a modern award, covered by an enterprise agreement, or below the high income threshold. Now, and the last one, is whether they've met the minimum employment period. Now, you can have individuals that are covered by a modern award or enterprise agreement and above the high income threshold. They still have access. And likewise, you can have people that are completely award free, but below the high income threshold. You just have to satisfy one of A, B, and C and have met the minimum employment period. So the minimum employment period for a business that has 15 or more employees, and that includes regular and systematic casuals, is 6 months. And for a business that has less than 15 employees, that period of time is 12 months. So an employee has to have met that period until they then have access to unfair dismissal. If we look at, not going to go into it too much, but if we look at Section 22 of the Fair Work Act, there are some things that are excluded in terms of what will make up the minimum employment period, and that does talk about things around unpaid leave. So if an employee is ever on the cusp and you're concerned about unfair dismissal, I do suggest that you seek advice and make sure that they either have or have not met the minimum employment period for particular reasons. We often get asked what is harsh, unjust, or unreasonable? What's taken into consideration? And look, the Fair Work Act actually stipulates, I think it's about 8 or 9 things that the Fair Work Act take into consideration as to whether something is considered harsh. And all of these elements here clearly have a link to procedural fairness requirements. If you're on this webinar and you're an HR manager, you're a current client, you speak to myself and the team all the time, these factors here are the reasons why we hammer home so hard on procedural fairness on process. So the first one is whether there was a valid reason for dismissal, if it's related to the person's capacity or conduct. So that would mean that there simply needs to be a lawful reason for dismissal, either that it was for conduct which is defined, it's for consistent poor performance, it is because of redundancy, it's because of something else. So you absolutely do need a reason to terminate someone's employment where they have access to make an unfair dismissal claim. Secondly, you do have to notify the person of that reason. And so it's really important here where you've got a termination letter. So we've clearly identified why the person has been terminated. We also need to think about here about whether they've been given the opportunity to respond to any of the allegations if it relates to conduct. So it's not simple enough to go into a meeting and provide a warning or go into a meeting and terminate without the employee knowing full well what allegations relate to and being able to provide a response to that. And we often say from a procedural fairness element that you actually need to consider that response before providing an outcome. Otherwise, it seems like you have gone into the meeting with a preconceived notion of what the outcome will be without really truly giving the employee an opportunity to respond. Now, this is a question that we get a lot around a support person. So an employer can't unreasonably refuse for an employee to have a support person present. So you don't absolutely have to offer it. It is not a fundamental must. However, this translates into a procedural fairness element, which I'll talk a little bit about later, around notice of the meeting. So how much notice should you be providing an employee that gives them an adequate time for them to organise a support person? So it's not seen as unreasonable refusal. So another one here relating to performance. So employees do have to be warned about their unsatisfactory performance before dismissal. And so that can often take the form of a formal written warning, but it does have to happen. We can't simply have one meeting and say that your performance hasn't been satisfactory and we're making the decision to terminate your employment. The Fair Work Commission, the last three we do look at, but they don't necessarily as much translate to procedural fairness requirements. But the Fair Work Commission does look at the degree or the size of the employer. They look at what kind of human resource specialists or expertise were in the organisation, and then there's any other matters that they consider relevant. So just a little bit about the maximum penalty on the risks. So for unfair dismissal, an employee can claim a maximum of 26 weeks' wages from a monetary compensation, and they often can sometimes ask for reinstatement. Other things that happen as well in an unfair dismissal claim is potential statements of service, having a termination be a resignation on a statement of service or something like that instead, to assist in them seeking further employment. With general protections, from a financial point of view, the claims are uncapped. So there's no limit on the amount that an employee can claim by way of damages. And we also need to think about that it's a civil remedy provision. So there can also be potential fines on employers where they've knowingly breached the general protections provisions. So now I just want to talk a little bit about the processes and the procedural fairness elements. So now that we've got all the risks in mind, what steps do we need to undertake and what do we do to make sure that these claims, even if they do come through, have likelihood of success? So the first one I wanted to talk about is performance management. So we talked about that element of factors considering harshness, where an employee has to be warned of the conduct before they are dismissed. So with this as well, I think it's really good to have formal performance improvement plans. And if you're going to do a formal performance improvement plan, there's no real rule on how long they have to be. But what you do need to consider is that it should be in writing. So the employee is told exactly what they are not doing and how they should be fixing it in order to prevent their employment from being terminated or prevent them from suffering any disciplinary action. They need to be objective and achievable targets. So we can't put requirements on an employee that are really unreasonable, because even where you've performance managed and provided warnings, it would still be considered harsh because you've asked them to do things that they may not be able to do or are outside of their remit. We need to give them a genuine opportunity to improve. So this might be a factor that you consider in terms of how long the performance improvement plan goes for. Where you've got someone who's been employed for a really short period of time, a couple of weeks might suffice. But if you've got long-standing employees, you might be looking at 4, 6, 8 weeks, maybe even a few months in terms of what the performance improvement plan looks like. Regular meetings and regular touch points throughout the period to progress is important, but also providing further training where needed. And if we're wanting to mitigate risks, and we're looking at termination without tears here, all of these elements, every touch point should be done in writing. And the employee should be provided with copies of the performance improvement plan and what's expected of them. And also, we should be keeping it on the employee's file if we later rely on it in the termination process. With misconduct, so this often looks like when we think about misconduct, it's not simply just anything that an employee may have done wrong. So misconduct can be defined as a breach of company policy. So you have a written tangible policy and the employee has breached a term of it. Serious misconduct, which is defined under the Fair Work regulations, which can look like intoxication at work, assault, serious and willful acts that are contrary to the terms and conditions of employment. So that's another element. Loss of trust and confidence is one that we get a lot, or where an employee might have lied about something. It's not always immediately a valid reason for dismissal on the spot. It's something that needs to be managed, and a full process needs to be undertaken to ensure that an employee has been able to give the opportunity to respond, and almost like performance, in that can we look at this and see whether there's any other way that we can manage a relationship where there has been a loss of trust and confidence, because you may not be able to rely on it if we're looking at a reason for dismissal. When you're dealing with misconduct, avoid delay. So if something arises, you need to deal with it as and when it arises. We can't let things build up and up and up, and then 3 months later something happens and we try and rely on conduct that happened 3 months ago in dismissal, because it was never dealt with at the time. You had knowledge of it at the time. If you think there's going to be something that leads to termination because there's a consistent pattern of behaviour, even if it's small, you still need to deal with it in a formal or informal sense and make sure that that's documented. So if we've got consistent patterns of behaviour and we get to our boiling point, we can say, we've spoken to you on this date, this date, this date, your performance or your conduct has been really consistent. And that's why it's now resulted in us having a meeting of this kind. And with misconduct as well, and whether we think about termination or a warning, there's this Briginshaw principle that we think about. So the more I'll take a step back. So when we look at misconduct, we as an employer or a manager need to determine on the balance of probabilities whether the conduct alleged did or did not occur. And so when you've undertaken your investigation and you've considered your responses, and you make the decision that you have determined that the conduct did occur, we look at the seriousness of the conduct, and we also look at the severity of the outcome. So the more severe the conduct and the more sure on the balance of probabilities you are, then it might be more fair, when we consider harshness, that termination would be the outcome. But where the conduct is not not necessarily serious, or whether your determination on the balance of probabilities is not as clear, then termination in that circumstance might not necessarily be the correct outcome, because they might want to see a warning or something like that at that point in time if you aren't really, really sure on balance whether the conduct did or did not occur. I just wanted to touch a little bit on redundancy here as well. So redundancy and whether redundancy is genuine is in the unfair dismissal jurisdiction. So we do need to think about here whether there's any consultation obligations. So there are specific processes, and a lot of these are governed by modern awards where an employee is covered by one, but you need to meet with the employee to discuss any potential impacts or the likely effect of procedural changes. You need to take measures to avoid those adverse impacts on employees, and you need to take into consideration their feedback. So if an employee's award covered and consultation obligations apply, one cannot simply meet with an employee to identify that their role is no longer applicable or no longer required to be performed by anyone, and tell them that their role will be made redundant in 4 weeks' time. There's no procedural fairness there. So whether an employee is covered by an award or an enterprise agreement and there are consultation obligations, the procedural fairness elements that we need to think of here are we need to have an initial consultation meeting with the employee to discuss the changes, welcome their feedback, and talk about the preliminary view that their role isn't needed to be performed by anyone. There is also an obligation here to offer redeployment. So that's a measure to avoid or reduce adverse effects. Are there any roles that the individual can perform within the organisation other than theirs that are currently available? And only once you have genuinely done those steps have you satisfied the procedural fairness requirements for a redundancy process and can close it out and notify the employee that they've either been made redundant and will exit the business, or alternatively, they are moving into an option of redeployment. So just moving on now to those quick little procedural fairness things, the absolute must that we need to remember in any sort of process, whether it is the termination itself or the process leading up to termination. And I would hope that if these things are done during the process, that the termination process already process leading up to it would hopefully be relatively seamless, and the risks of the real risks of unfair dismissal, or successful rather unfair dismissal and general protections cases would be mitigated. So first step, inviting an employee to a meeting. So there is no legislative requirement around how much notice you're required to give an employee, but typically we advise that 24 hours notice in writing is sufficient. And in that invitation, you can invite them to bring a support person. So that doesn't have to be a formal letter. It can be an email, but we just need that to be in writing. It is recommended that you provide an employee with detail in the invitation letter about the allegations of conduct or performance. So the real details. So they're getting an invitation letter and they can look at that and think, okay, I know what I'm being brought in to talk about, and I can provide an adequate response now in relation to these allegations. You'd also want to identify who will be present at the meeting and the time and the location. And another thing that you can consider is just when the employee will be working. Now, this is just one of those courteous things. If you're meeting with an employee to discuss their performance or conduct and you meet with them first thing in the morning, it might really impact their productivity or their kind of mood for the rest of the day. So can we try and schedule them towards the end of the day? Make sure that you do these meetings while an individual is working. Otherwise, if they do come to work on a time where they're not normally working, you would generally be required to pay them because they are making themselves available. Drafting a warning. So these are really important because we talked about the procedural fairness elements for termination that relate to warnings. So a warning can't simply just be given to an employee following no discussion around the areas of misconduct. You do need to have a disciplinary meeting or a performance meeting with them before and seek their responses prior to the warning being given. if it relates to performance, a formal warning should be provided after the conclusion of a performance improvement plan where there's been no improvement, not prior to a performance improvement plan being initiated. The formal warning must tell the employee why they have been warned. So it can't be enough just to say, here's a formal warning. It needs to say, here's a formal warning for areas of misconduct relating to, on this date in September, you engaged in misconduct that is in breach of our code of conduct policy, etc. And you would talk about what that is. You also need to state the implications of the warning being given. So if you do engage in further conduct of this nature, you will be subject to further disciplinary action, not limited to termination of employment. So that's a procedural fairness element in the unfair dismissal section. So the employee knows what the outcome is if they do this conduct again, and keep a record of the warning as well, so that if we are relying on it in termination, you can later look back on it. Termination meeting itself, same procedural fairness elements apply. So if we've done 24 hours notice in writing and invited them to bring a support person to a misconduct or a performance meeting, the same will apply to the termination meeting. Relating to that unfair dismissal element of harshness, you do need to communicate the reason to the employee why they are being terminated. And generally that will be by providing them an outcome. If it's relating to conduct, it would be that the conduct that it's alleged that they've been engaged against is substantiated and it has followed a series of warnings. Or performance, it would be that they've been on consistent performance improvement plans with warnings and have failed to improve. If you have an EAP provider, you can provide this to an employee during the termination meeting for them to utilise, but also any of those other processes leading up to the termination meeting itself. And lastly, communicate the reason for the termination to an employee in writing, generally in the form of a termination letter, because there is that requirement that there was a valid reason for dismissal in the first element of the criteria for considering harshness in the unfair dismissal jurisdiction. So I think Annette might jump on now. That's all from the presentation part from me.
Thanks, Em. Again, thank you. That was a very insightful presentation, Em. I just want to remind everybody about the benefits of HR Assured there on the screen. But I think we will jump straight into questions, Em, because we have a lot.
Yeah, I'm happy to answer a few more if people are wanting to sit around for them to be answered.
Great. Okay, I'm going to kick off with this one.
Sure.
What happens when an employee raises a complaint during a termination or disciplinary meeting?
Okay, look, so this happens a lot. So sometimes employees do raise complaints in the form of a disciplinary or a performance meeting because they anticipate that they will be terminated or they anticipate that they will be provided with a warning. It's a complex one, but general rule of thumb is where the complaint or dispute is in relation to the process itself that you are undertaking, that should be the complaint should be investigated and closed out prior to any warning or termination, so prior to any adverse action, because it's in relation to the process itself. If it's completely unrelated and it's just got nothing to do with the complaint, then look, you can have the two processes occurring side by side. So you continue with your disciplinary or your performance or just termination process, but you would launch a second investigation in relation to the complaint that they've raised, whatever that will be.
Great, thanks, Em. Okay, we'll move on to the next question. Okay, we will go to this one. Can you outline handling termination when a worker is on workers' compensation, i.e. has not returned to their role within 26 weeks of no capacity for suitable duties?
I can incredibly briefly, and the reason I say that is because termination in relation to when they're on workers' compensation is dealt with on a state-by-state basis. So there are a number of differing answers. Generally, where an employee is on a workers' compensation claim and that claim has continued for a period, that can remain. But sometimes an employee has been on an absence, the workers' compensation claim, so to speak, has finished, and we need to terminate the individual. Look, my general suggestion is just have quite close contact with your insurer or the kind of case manager who's assigned to the matter, because we just really need to look at whether the individual, what the most recent medical certificates are, what do they say. You might even direct them to attend an independent medical examination to see whether they have the ability to return now or in the reasonably foreseeable future. If they do, then you facilitate a return to work. If they don't, then at that point in time, yes, sometimes you can look at terminating employment on that basis. But look, sorry if it's not a specific enough answer, but it is absolutely dealt with on a case by case and state by state basis. So there's a lot of variables.
Okay, thanks. What are the risks of failing to have regular catch-ups or touch points throughout the PIP period, which is a performance improvement plan?
Sure. Well, look, I think the risk just goes to whether you've conducted. It's generally in unfair dismissals, whether it's harsh, unjust, or unreasonable. And I think it really relates to if you've given an employee a performance improvement plan for 4 weeks, you give it to them, you say, okay, all right, off you go. Go and fix your performance. You're not really genuinely trying to enter into a performance improvement process. So even where you're giving warnings or you terminate, you haven't genuinely tried to get them to improve. That's the goal. Performance management is not a means to termination. It is a means to get an employee to improve and be able to perform their role. And if they can't perform, that's fine, and it does result in warnings or terminations. But if you're not having regular catch-ups or providing training with an individual, you haven't genuinely tried to performance manage them. And so the risk, I think, there would be around the unfair dismissal jurisdiction and your warnings and performance management process, and whether it's considered harsh in the circumstances, considering the lack of potentially genuine performance improvement on behalf of the employer.
Okay. Could a support person be their spouse? So I guess the question is, who is a support person for the employee?
Yeah, look, a support person can be lots of people. It can be their spouse. It can be another employee where having that individual won't cause issues in relation to confidentiality. It might be a union rep. It can also sometimes be a solicitor, but generally where your support person is a solicitor, they're not acting in the capacity of a solicitor. They're just simply there as your regular support person to provide emotional support to the individual in the process. So the answer is yes, absolutely, a spouse can be a support person.
Perfect. Okay. Do unfair dismissals relate to casual employees?
Yes, they do. So they still have to have met the minimum employment period of 6 or 12 months. However, it does. So if you've got a casual that is very rarely working, they're by no stretch of the word considered regular and systematic, they can still make a claim, but their ability to be successful in that claim is generally mitigated. But where you have a regular and systematic casual who's had work for more than 6 or 12 months, then yeah, absolutely, they do have access to unfair dismissal, and you generally would still have reasons for termination. So obviously, if they're casual and with the new definition of casual employment in the Fair Work Act, if they are truly by nature engaged on an ad hoc basis and that kind of thing's been communicated to the individual, then that the risk would be mitigated, or where it's related to conduct or performance. But absolutely, you still need a valid reason for dismissal, which is the first element in considering harshness for an unfair dismissal.
Thank you. There's quite a few comments asking if the slides will be available. We will be sharing the recording, which will have the slides of them. So look out for an email from Em after the webinar. Next question for you, Em. If a redundancy is required in the business for a specialised skill set role with which is genuine, and there is no other role available for them to be redeployed into, how can a company demonstrate they have offered them other options when there really isn't one?
Well, if there truly aren't any other options, you don't necessarily have to offer, but you have to demonstrate that you have explored. So if you're making the individual redundant and you truly have no other roles, then that's fine. You can communicate that, look, we have looked at every other avenue, we've assessed costs, we've looked at other teams, we have no vacancies that we're currently advertising, and there is no other role, even in a casual capacity, that we can give you. And that's perfectly fine. But we just need to demonstrate that that's occurred. It's not simply enough to say, oh, no, I don't think so. And that's particularly important when you're in a larger organization. If you're in a smaller organization, you can generally know whether there's other roles, but you even think about, are there roles in different cities or different locations? All that kind of thing is something that you need to consider. And with that as well, you also consider potential, if there's any small upskilling that you can give the individual to perform a vacant role, then that would be something that you consider there as well.
Okay. This one's an interesting one. What happens if an employee starts swearing and they leave the meeting because of anger? Do you have to give a warning, or that is ground enough for termination, as an employee does not see this as unreasonable behaviour?
If an employee starts swearing or going off in a meeting, I would cease the meeting and allow them the opportunity to leave. You still need to follow through with your best practice process. So if an employee hasn't adequately provided responses because they were being angry, then you might just give them the opportunity to do that in writing. In saying that, if an employee is acting unreasonable in a disciplinary meeting, it adds on another element of misconduct that you need to deal with in the course of these proceedings. So if you were giving a warning to an employee for driving unlicensed in a work vehicle and they come in and they're swearing in the meeting, the warning or termination, whichever that might be, might not only because they were not wearing a belt in a work vehicle, they were also swearing during the meeting. So there's no perfect answer to that, because again, it's all dealt with on a case-by-case basis. So I'd be looking at how long's the employee been there for? Is this the first time they've ever engaged in misconduct? Are they likely to do it again? Have there been any warnings previously? And if this is a troublesome employee, then yes, it might be more fair to terminate because of their kind of behaviour in the conduct meeting. But look, that's not always the right answer.
Okay. This one is a redundancy question for a small business with just 4 employees. Is redeployment really an option? Surely that is considered, I guess the size of the business is what their kind of angle is on that question.
Well, yeah, you still have to consider redeployment, but it's kind of like what I talked about before, in that there just may not be any redeployment, but you still have to demonstrate that you've looked and that you've considered all your options, even when you're a small business. If you're a larger business, your exploration for redeployment might be more complex and extensive. But if you're a small business of 4 employees and one of you have to be made redundant, then you kind of look at it and think, they're full-time, could we offer them part-time, could we offer them casual? If not, and there is not a single other piece of work that needs to be done by the business, then as long as you've communicated that to the employee and you've undertaken that process, you've satisfied your element for exploring redeployment options and exploring any mitigating circumstances that may reduce the adverse effect on the employee.
Great. Okay, drafting a formal warning letter. If we issue one after a meeting, does it need to be signed by the employee, or would an email trail showing it was sent to them suffice?
Look, they don't have to sign it. Get this question a lot because they're going, the employee isn't signing and agreeing to what we're giving them a warning for. An employee doesn't have to agree. The employer has made the decision that they have determined on the balance of probabilities to the reasonable satisfaction whether the conduct did or did not occur. So they don't have to sign it. However, if it's been given to an employee at the end of a meeting, yes, I would think if you've sent it to the employee and you can demonstrate via email that it has been given, even when the employee says, 6 months down the track, I never agreed to it, I never signed it, we're saying, that's fine, it's sent to you, we have record of the fact that it's sent to you, you have been warned of the conduct and you have been warned of the likely outcome if you engage in that conduct again.
Okay. This is a good question. if there is a lower paying job, can you offer that to them as an option if there is absolutely no other job position? I'm assuming this is in regards to a redundancy.
Redundancy. Yeah, absolutely. So they use this term reasonable redeployment. And so where there's a slightly lower paying position, that you can certainly offer it, an employee can accept or decline. The employee might just be of the view that it's not necessarily considered reasonable, considering the reduction in pay, and they might, they've got things like a mortgage and kids and bills and all that kind of thing that they need, things that they need to be able to upkeep at the salary bracket that they were at previously. So they might choose in those circumstances to be made redundant. And if you're a large business, they'd be getting redundancy pay. So yeah.
Okay. Another juicy one. Can a support person be a board member? We have had an employee request the president as their support person.
So it's an interesting one. So where it really depends on what the investigation relates to and who is the ultimate decision maker in relation to the conduct. So you potentially can. You could technically have someone on the board as a support person. However, I would really kind of want to, it's a really good question. I think that one could be a whole discussion in and of itself, but it would really depend on what the investigation relates to and whether they were in the capacity of a board member in order to assess the conduct of the employer, or that's what the employee thought, or whether they were more in the capacity of a kind of a friend or a colleague. So yeah, look, it's a good question. I don't know if I have a straight answer to it, but I'd be really interested to have a conversation around that as to what the conduct related to. Because the answer is, one more bit on this one, you can't unreasonably refuse. So it's not that the employee has an absolute fundamental right to the one individual that they nominate. If you are of the view that, considering the nature of the conduct and that's being investigated, or the nature of the performance or anything like that, that there would be a potential conflict should a board member be a support person, then you can say, in our view, it presents a conflict and we are refusing the ability for you to have that particular board member. However, you can bring other people. It's unreasonable refusal, and that wouldn't necessarily be reasonable. They can bring any other person besides a board member in your view, or someone related to the investigation. So I hope that helped a little bit.
Okay. All right, Em, I think we have to wrap up questions, but we do have quite a few that are unanswered. So I do have a solution for that if we go to the next slide. I wanted to offer everyone who is not already a HR Assured client an opportunity to try our advice line for free. So if you do need some workplace advice, we can assist you, and someone in our team will be in touch with you after the webinar to arrange this. And if I could get you to go to the next slide there.
Sure. I think we've already got that part.
There we go. Yeah, we have. So I'm going to send everybody that link, because that is where you'll need to go to make, I guess, a booking for a consultation call. And then also, we will be sending everybody an email after the webinar with links to this recording and also a free ebook on redundancy. For all of our existing HR Assured clients, thank you for your support. And as you know, you already have access to our telephone advisory service. So if you do need to seek advice and support, please call us anytime. I think that wraps everything up, Em. Thank you so much for an awesome presentation. I'm pretty sure a lot of people got a lot from that. So thank you.
Awesome. Thank you. Yes, there was a lot to get through in a short period of time, but I hope there was some takeaways from everyone. So I hope everyone has a fantastic rest of your day.
Thank you. Bye.